Shawna Benoit here, and today we're talking about the exclusive seller brokerage engagement agreement. State law prohibits broker from representing seller as a client without first entering into a written agreement with the seller. Key terms and conditions. The seller and the broker are agreeing to work together exclusively. Broker represents the seller in listing and selling the property. This section identifies the property's address, county, zip, tax ID, and thereof. The legal description. The contract gives several choices for how the property's legal description is provided. One, you can attach a copy of the deed. Two, the legal description found in the county deed tax records with a book and a page. Three, a land lot, subdivision, block, unit, phase, plat book, and page. Or four, if the property is in a condominium, the full legal description will go here. Two, the list price and listing period. The amount the seller is choosing to list the property for. Start date, the date the agreement becomes active. It must be signed and delivered to both parties to take effect. C, ending date, the date the listing agreement expires unless extended in writing. D, listing period. This is simply another term for the start and end date time frame. Marketing. Name the MLS the broker will use, such as FMLS or GAMLS. Delivery of the listing to the MLS. The listing must be submitted to MLS in accordance with the MLS rules. MLS rules override anything in the agreement. MLS rules may limit marketing options such as coming soon. Marketing commencement date. This is the date the property is first marketed to the public. The seller can move this date up or back a few days. And this concludes page 1 of the listing agreement. Page 2 of the listing agreement, coming soon. The property can be listed as coming soon for a set number of days. It cannot be shown or sold during that time. Afterwards, it switches to active. D, MLS marketing option. The seller selects one of these. 1, immediate public marketing. It immediately appears in the MLS, goes to Zillow, Realtor.com, broker's website, etc. Full public disclosure. 2, delays marketing attempt. Visible in MLS only for agents initially. Delays distribution to Zillow, Realtor.com, etc. Still an active listing can be shown. 3, office exclusive marketing options. Marketing only inside the listing brokerage initially, not shown in MLS to other agents. No public advertising. E, disclaimer. If the seller delays public marketing, option 2 or option 3, they may lose exposure, fewer offers, and potentially get a lower price. Seller acknowledges and accepts the risk. 4, compensation to brokers. Compensation is negotiable. Georgia law does not set compensation rates. Seller pays broker. Seller agrees to pay the listing broker's compensation at closing. This could be a percentage of the sales price, a flat fee, another custom structure. C, compensation offered to buyer's broker. Seller chooses whether they are offering compensation to a buyer's agent, how much, a percentage or flat fee they are offering to the buyer's agent, whether the listing agent is paying it from their compensation, or whether no compensation is offered to buyer's broker. D, separate compensation on leases. If the seller leases the property during the listing period, they owe a separate leasing fee, and this is in addition to the normal sales compensation if the property later sells. And this concludes page 2 of the listing agreement. Page 3 of the listing agreement, protection period. This is the time frame after the agreement ends when the broker is still protected. A buyer who saw the home during the listing period or was given information about it. Buyer buys the home during the protected period. The seller still owes compensation. The number of days is written in the blank. 6, agency and brokerage. Types of agency not offered. The broker checks which type of agency relationships they do not provide. Dual agency consent. If dual agency is offered, seller chooses whether they agree or do not agree to allow the broker to represent both sides, the seller and the buyer, simultaneously. If they agree, they must understand the limited role the broker plays in dual agency. Lead-based paint disclosure. Federal law requires disclosure for any home built prior to 1978. Seller checks whether the home was built before 1978 and attaches the required lead-based paint exhibit, F316. Seller special circumstances. Certain situations require third-party approval. For listing, bankruptcy, divorce, other court-required approvals. Contract to sell the property. Bankruptcy, divorce, short sale, seller not on the title, or other. These ensure there are no legal surprises that prevent the sale. Negotiations. Seller indicates whether they authorize the broker to assist with negotiations, help fill out pre-printed contract forms. Exclusive brokerage engagement explained. Seller has full authority to sign this agreement. The contract can't be changed unless both sides agree in writing. The seller has a previous listing agreement still active. They may owe the broker compensation. List price and listing period. If the home doesn't show or sell, price may need reassessment. If the home is under contract when the listing expires, the listing extends automatically through closing. If a contract falls apart, broker can extend the listing equal to the number of days the home was under contract. And this concludes page 3 of the listing agreement. Page 4 of the listing agreement. Marketing. Broker controls marketing. Seller agrees not to market the property on their own. Marketing materials ownership. Broker owns photo materials if they pay for it. Seller owns materials if they pay for it. Accuracy. Seller must provide true and accurate information. D. Photos and privacy. Seller should remove anything they do not want photographed. Broker isn't liable if others take photos during showings. E. Multiple listing service filing. Broker must submit the listing within 1 business day of the marketing start date. F. Do not call rules. Seller allows broker to call even if seller is on the do not call list. G. Lockbox liability. Seller must secure viables and medications. Broker is not liable for misuse of lockbox. Compensation for professional services of seller's broker. Seller must pay broker if property sells or leases during the listing period. If the seller enters into any of the following during the agreement: a contract to sell, a lease purchase agreement, a lease with an option to purchase, then the seller owes the broker a compensation at closing. The lease fee at closing, if applicable. B. Optional compensation to buyer's broker. This paragraph explains how payment to the broker's agent works. Sellers are not required to pay a buyer's broker, but many choose to offer compensation to attract more buyer agents. If the seller agreed earlier to offer a buyer brokerage compensation, then it must be paid at closing. If the seller did not agree to offer it, the buyer must pay their own agent directly. C. Separate compensation on a lease. If the seller leases the property instead of selling, they owe a separate lease compensation agreed upon in Section 8. This is true even if the lease turns into a lease purchase or a lease with the option to buy. These lease fees does not replace the listing compensation. It is in addition to the sales compensation if the property eventually sells. Protected period. This explains what happens if a buyer saw the property while it was listed and tries to buy it after the listing expires. The broker is protected during this period if the agreement expires or the seller unilaterally cancels the listing. If buyer who saw the home in person or virtually or received information about the home through any agent during the listing period buys or leases the home during the protected period, the seller still owes compensation. Exceptions. If the listing expired naturally and the seller signs a new exclusive listing agreement with the new broker, and the property sells within the new listing period. 6, agency and brokerage. Broker's agency options. This clarifies what agency relationship the broker offers. Seller agency, buyer agency, designated agency, dual agency, sub-agency, landlord-tenant agency. Unless the broker checked the box earlier saying they do not offer one of these. And this concludes page 4 of the listing agreement. Page 5. Here we go. Dual agency. Dual agency disclosure explained. Dual agency means the broker has 2 clients with potentially opposing interests. Example, seller wants the highest price, buyer wants the lowest price. Broker must disclose all adverse material facts they actually know. Seller does not have to agree to dual agency. Consent is totally voluntary. Confidentiality is required. Broker must keep the seller's negotiating information private unless law says otherwise. Broker must disclose any personal or business relationships with the buyer that could affect neutrality. Once the seller signs the agreement and consents, state law treats the consent as informed and valid. Designated agency disclosure. One licensee represents the seller. Another licensee in the same brokerage represents the buyer. Each agent owes their client full loyalty, confidentiality, and advocacy. This helps avoid the conflict of dual agency. D, no other conflicts. Broker confirms they do not have any other relationship that conflicts with the seller's interests. They may represent other buyers or sellers in unrelated transactions. 7, lead-based paint disclosure. If the property or part of it was built prior to 1978, the seller must disclose any known lead-based paint or hazards. Provide any report records they have. Give buyer the EPA pamphlet. Allow buyers a 10-day inspection window unless waived. The requirement is federal law under the Residential Lead-Based Paint Hazard Act of 1992. Special circumstances, a third-party approval. If something in the seller's life affects the right to sell, such as bankruptcy, divorce, short sale, etc., seller must take responsibility for getting any required approvals. Any purchase agreement must reflect these contingencies. B, confidentiality. Broker must keep confidential anything the seller requests to remain confidential, unless the seller later allows disclosure or the law requires the broker to reveal something. However, buyers and their agents are not automatically required to keep the seller's information confidential unless they sign a confidentiality agreement. Accuracy requirement. Broker cannot give false information to customers. If there is a conflict between being truthful and keeping the seller's confidentiality, Truthfulness wins by law. Negotiations. If the seller wants negotiation help, broker may assist in negotiating and preparing pre-printed forms. All final choices such as price, terms, counters remain completely up to the seller. Broker is not allowed to make decisions on the seller's behalf. And this concludes page 5 of the listing agreement. Okay, we're going to take it from the bottom of page 5 and go into page 6. Seller's property disclosure statement. Georgia law requires sellers to disclose known hidden defects even when selling as is. Seller must provide the broker with one of the GAR disclosure forms within 3 days. The F301 single family disclosure, the F304 new construction, F307 condo disclosure, or the F302 latent defect and fixture checklist. Keep the disclosure update through closing. Broker is authorized to give these disclosures to buyers. Page 6, hazard conditions on the property. This is a major liability warning. Seller acknowledges broker has no duty to inspect the property for hazards or repairs. Seller must keep the property reasonably safe for buyers, agents, inspectors, and contractors. Seller must warn visitors about dangerous conditions that are not obvious, fix hazards when possible. Seller agrees to indemnify broker if someone gets hurt on the property due to unsafe conditions, no warning, pets not secure. Seller is responsible, not the broker. Limits on broker's authority and responsibility. Broker can show other properties. They may work with the other buyers and sellers as normal. B, broker does not inspect or advise on specialized matters. Broker is not responsible for surveys, appraisals, title search, termite wood infestation report, radon, mold, asbestos testing, septic or well inspection, structural engineering, zoning flood assessments, tax, legal, or financial advice. C, broker only has authority stated in this agreement. They cannot sign contract for the seller, make decisions for the seller, give legal advice. D, broker must disclose required legal information. E, seller, not the broker, is responsible for meeting contract deadlines. Example, inspection deadlines, financing deadlines, repair obligations. F, seller must indemnify or protect the broker for certain issues. The seller agrees to protect the broker from liability when issues arise from incorrect or incomplete information provided by the seller, earnest money handling by someone other than the broker, seller's negligence or wrongdoing. Theft, loss during showings or open houses, undisclosed material facts about the property, injuries caused by unsafe property conditions or unrestrained pets. Limits on broker's liability. Seller acknowledges that Broker shall under no circumstances have any liability greater than the amount of compensation paid hereunder to broker, excluding any compensation amount paid to a cooperating real estate broker, if any, or if no compensation is paid to broker than the sum of $100. Broker shall have no liability for providing information that later turns out to be incorrect or false, provided that broker did not have actual knowledge that the information was false and disclosed to seller the source of the information, and notwithstanding the above, shall have no liability in excess of $100 for any loss or funds as a result of wire or cyber fraud. This limitation of liability shall survive the termination of this agreement. Disclosure of potential fraud activities as required by the Georgia Residential Mortgage Fraud Act. To help prevent fraud in real estate transactions, seller does hereby give broker permission to report any suspicious, unusual, and/or potentially illegal or fraudulent activity, including but not limited to mortgage fraud, to government officials, agencies, and/or authorities, and/or any mortgage lender, mortgage insurer, mortgage investor, and/or title insurance company, which could potentially be harmed if the activity was in fact fraudulent or illegal. B, seller acknowledges that broker does not have special expertise with respect to detecting fraud in real estate transactions. Therefore, seller acknowledges that activities which are fraudulent or illegal may be undetected by broker, and activities which are lawful and/or routine may be reported by broker as being suspicious, unusual, or potentially illegal or fraudulent. And this concludes page 6 of the listing agreement. Page 7 of the listing agreement. Arbitration. If there is a dispute between the seller and the broker involving this agreement, it must be resolved through arbitration, not a traditional lawsuit. Federal Arbitration Act rules apply. Both sides will try to agree on a Georgia-based arbitration company. If they can't agree, each side submits a list of 3 acceptable arbitration companies, and a selection process follows until one is chosen. The arbitrator decision is final. The arbitrator may award attorney's fees and costs. There can be no class actions. Claims must be brought individually. Expectations. Arbitration does not apply to disputes over earnest money handling, broker disputes about being paid for their compensation. Assignability. If the brokerage is sold to another firm, this agreement can transfer to the new broker. The new broker must accept the assignment. Once assigned, the new firm takes on all duties and earns the compensation. Simply explained, if your agent's brokerage is bought out, your listing agreement automatically moves to the new company. Attorney's fees. If there is arbitration or litigation related to this agreement, the winning party is entitled to recover their attorney's fees. D, broker. The meaning of broker includes the brokerage firm itself and all affiliated licensees involved in the transaction. E, definition of seller and buyer. This section explains the definition of seller and buyer to prevent loopholes. Seller includes the seller, their immediate family, any business entity they own 10% or more of, Anyone acting on the seller's behalf. Buyer includes the same category. To prevent someone close to the seller or buyer from trying to get around this agreement, rules like who owes compensation. F, foreign ownership restrictions. Georgia law restricts certain foreign nationals and companies from buying agricultural land, land within 10 miles of a military base, installation, or military airport. Seller acknowledges they must understand this law. They must seek legal advice if unsure. Broker is not responsible for explaining or monitoring compliance. If the seller doesn't ask questions before listing, it is assumed they fully understand the law. Failing to comply can lead to civil criminal penalties. G, entire agreement. This paragraph confirms the contract replaces all previous agreements, written or verbal. No promises outside this document are enforceable. The agreement is binding on the seller's heirs. Exhibits and addenda control over conflicting language in the main document. Fair housing disclosure. Seller and broker agree not to discriminate based on race, color, religion, national origin, sex, familial status, disability, sexual orientation, gender identity. This reinforces federal and Georgia fair housing laws. I, FERPTA affidavit. At closing, seller must sign an affidavit stating whether they are a foreign person. If seller is a foreign person, additional tax withholding may apply. If seller is not foreign, they sign a standard affidavit. J, GAR forms. GAR forms disclosure. GAR forms are optional, not required. They are standardized forms not written specifically for either party. Sellers should read them carefully and consult legal counsel if they have questions. Courts sometimes interpret or strike down certain GAR provisions. These forms are widely used and reliable, but they are not legal advice and may not cover every scenario. And this concludes page 7 of the listing agreement. Page 8 of the listing agreement. K, governing laws and interpretation. Georgia law applies. The contract may be signed in multiple counterparts. If any part of the agreement is unenforceable, the rest remains valid. The agreement does not favor either party based on who drafted it. I, independent contract relationship. The broker and licensees are independent contracts, not employees of the seller. M, no imputed knowledge. One agent in the brokerage is not automatically known by the entire company. Only actual knowledge counts. N, notices between seller and brokerage. Real estate transaction communications. Seller must remain reasonably unavailable during the listing period because many communications are time sensitive. Notice about this agreement. Notices must be in writing and signed. They may be delivered in person or to any address, email, fax listed in the agreement. If the seller does not provide an email, that means that the seller will not accept notices via email. O, referrals. Seller authorizes broker to refer them to other agents, relocation companies, builders. Brokers may receive a referral fee. This is legal and disclosed. P, statute of limitations, 1 year. Any claim against a broker lawsuit, or arbitration must be brought within 1 year of when the issue occurred. After 1 year, the seller is legally barred from bringing the claim. Q, survival. Certain sections survive the end of the listing agreement, including broker's right to compensation, limitation of liability, arbitration requirements, indemnification provisions. R, third-party vendors. Broker may give vendor names as a courtesy, but does not guarantee their word, does not assume liability for vendors. Sellers must perform their own due diligence before hiring anyone. S, time is of the essence. Deadlines matter. Missing a deadline can cause loss of right, breach of contract. T, the use of NA means not applicable. 7, broker and seller's duties. A, broker's duties to seller. The broker must try to obtain the best price and terms for the seller. Broker works to get the seller's desired price and condition. Broker does not have to seek additional offers once the home is under contract unless the agreement states otherwise. Present all offers promptly. The broker must deliver every offer to the seller, even if the property is already under contract. Disclose material facts they actually know. If the broker knows something important about the transaction, they must tell the seller. 4, advising seller to obtain professional help. If something is outside the broker's expertise, legal, structural, tax, etc., they must advise the seller to get an expert opinion. 5, account for money and property. If the broker handles any funds or property, they must track and report it properly. B, broker must maintain confidentiality. The broker keeps confidential anything the seller specifically asks to keep private, unless the seller later gives permission or the law requires disclosure. Sharing information with other licensees within the brokerages who are helping with the listing does not violate confidentiality. C, seller's duties. The seller agrees to cooperate fully with the broker. Make the property available for showing. Provide truth and complete information. Follow all laws affecting the sale. Read and honor all contracts. Seller must understand the following deadlines in the purchase and sale agreement once signed. And this concludes page 8 of the listing agreement. Page 9 of the listing agreement. This section explains how the seller can breach the agreement and what happens when they do. What counts as seller default? The seller is in default if they terminate the agreement early without broker's written consent. If the seller cancels unilaterally, it is a breach. 2, fails to close a signed contract because of seller's actions. If the seller breaches a purchase agreement and causes the deal to fall apart. 3, agree with the buyer to cancel the purchase agreement without the broker's consent. Broker must agree to terminate since it affects compensation. 4, refuse a full price, clean cash offer. If the seller refuses a legally valid offer that meets all of the following: cash or cash equivalent, at least full list price after deducting seller paid closing costs, No contingencies, no due diligence, no financing, no appraisal, no special stipulations. Only required warranties are whatever is already in the seller's disclosure, promise to transfer good and marketable title at closing. Closing date is 30 to 45 days from the offer date. Property is now already under contract. Multiple offer exceptions. If multiple full price clean offers come in, seller has up to 10 days to allow all buyers to submit their best offer. Choosing one of them does not count as default. B, broker remedies for seller default. If seller defaults, seller must immediately pay the broker the full compensation, except in the case of early unilateral termination. This situation falls under the protected period rules. The protected period determines whether the broker still earns compensation after termination. Seller default. C. Seller must reimburse broker for out-of-pocket costs. If the seller defaults, the seller must reimburse the broker for marketing expenses, printed or advertised, mileage at the IRS business rate, MLS removal fees, any other costs spent to list and market the home. These payments do not eliminate the seller's obligation to pay the full compensation, but any reimbursement the seller pays will reduce or offset the total amount owed under future compensation claim. Warning to buyer and seller, beware of cyber fraud. This is the most important section of the entire agreement because wire fraud attempts are extremely common in real estate. Key points explained simply. Criminals impersonate real estate professionals. Hackers may pretend to be mortgage lenders, closing attorneys, the real estate broker or agent, the title company. They send fake wiring instructions to trick buyers or sellers. Hackers send fraudulent emails that look real. These emails may come from addresses that look identical or nearly identical to official ones, include correct names, signatures, or logos, contain urgent or last-minute updates. The goal of these scams is to steal the buyer's earnest money, buyer's down payment, the seller's proceeds, any other wired funds connected to the closing. Once wired, the money is often impossible to recover. Critical safety instructions for clients. Always verify wiring instructions over the phone using a trusted number. Never call the phone number listed in the email with wiring instructions. Look up the phone number yourself from the attorney's website, a business card, a previous verified email, or by contacting your agent. Be extremely cautious of wiring instructions for a bank in another state. Email addresses that are off by just one letter or number. Never trust wiring instructions sent to you by email. Always confirm by calling the closing attorney directly using a verified phone number. And this concludes page 9 of the listing agreement. Okay, here we are on page 10, brochures. This section lists guard consumer protection brochures the seller has received. Seller checks whichever brochure they receive, such as the ABCs of agency, lead-based paint pamphlet, mold pamphlet, EPA Guide to Radar, protect yourself when selling real property, short sale and distressed properties, buying agricultural land and land near military bases, other here, exhibits and addenda. This contract may have other documents attached to it called exhibits and addenda, and all of them become official, legal, binding parts of the agreement. If there is ever a conflict between the language in the main agreement versus an exhibit or addenda, the exhibit or addenda override the conflicting language. This protects the seller by ensuring that customized terms include special stipulations control the agreement. Simply explain special stipulations. Anything handwritten or typed in the special stipulations section becomes the #1 controlling language, even over the pre-printed GAR form. And this concludes page 10 of the listing agreement. Page 11 and final page of the listing agreement. By signing this agreement, seller acknowledges that seller has read all provisions and disclosures made herein. Seller understands all such provisions and disclosures and has entered into this agreement voluntarily. And 3, seller is not subject to a current seller brokerage engagement agreement with any other broker. If a licensee is signing this agreement on behalf of the broker, licensee warns that licensee has full authority to sign this agreement and bind broker hereto. Seller's acceptance and contract information. If seller is a legal entity, this agreement must be signed by one or more authorized persons as required in the entity's legal documents. The person signing must include the capacity in which the person is signing, such as trustee, general partner, manager, president, etc. For our example, we have a seller here. We have her information, her signature, the property address, phone number, email address. For this demonstration, we only have one seller. If there were 2 sellers on a deed, the second seller would sign here with the completed information. If there is more than 2 sellers, we attach additional signature pages, which is the F146. Broker's affiliate licensee contact information. The broker or the broker's licensee information would be here, fully signed. The address and the brokerage information would be here. Receipt of copy of this agreement is hereby acknowledged by the seller. So now, because everyone has signed, this is considered a binding agreement, and the seller would get a copy, the broker would get a copy. This concludes the listing agreement. Thank you.